Okay, welcome everyone. Thank you for attending our 8th lecture and our final lecture in our Mrso certification course. I'm Jason Parker. We're going to be talking about medico-legal implications of MRI safety today. This is a topic that really is not very well covered in the literature when it comes to MRI safety specifically. There are plenty of examples of the medico-legal implications of safety in radiology departments specifically. As you can imagine, there's lots of cases that have been tried and settled and evaluated with respect to ionizing radiation, but we don't have a lot of good cases to work from in the area of MRI safety. Nonetheless, there are a handful of good papers that have tried to summarize what some of the primary medico-legal ideas are that MRSOs, MRMDs, and MRSEs should be familiar with. I'm using the syllabus from the ABMRS today to structure this talk, which is very brief. I'll show you the actual syllabus at the end, but there's really 3 or 4 big ideas that they want you to be familiar with. I've also looked at a number of practice tests from different organizations for MRI safety for MRSO and MRMD certification, and can't find many questions on medico-legal implications. So I don't think that this is a topic that is thoroughly covered on the more formal tests, but it is something that's recommended we be familiar with. So it'll be somewhat brief. If you have any questions, please feel free to ask. We'll start off by talking about medical malpractice and then get into standard of care and the definition of standard of care. It's important to understand that standard of care is the guiding principle by which we assess whether or not negligence has occurred in the MR safety, in the practice of MR safety. I'll talk a little bit briefly about history, and then go into kind of current interpretations of standard of care as it relates to MR safety. I'll talk about the captain of the ship doctrine, which is an actual legal doctrine that originated from surgery, that's used quite a bit in medical malpractice in the US. Move on to vicarious liability, which really is very similar to captain of the ship doctrine, if not completely the same, but they're mentioned separately on the ABMRS syllabus. So we'll kind of attack them from separate angles. I have one example. Unfortunately, it's not an MR safety example because I couldn't find a good MRI safety case that had actually been litigated where I could get good information on the different parties involved and how it was resolved at the end. And then a little time for Q&A. Okay, so the first attempts at regulating medicine that I could find began with the Code of King Hammurabi, which was back in the First Babylonian Empire. And this is actually the actual code of King Hammurabi. And this set of laws actually tried to regulate medicine. And it specifically stated if the doctor has treated a gentleman with a lancet of bronze and has caused the gentleman to die, or has opened the abscess of the eye of a gentleman with a bronze lancet and has caused the loss of the gentleman's eye, one shall cut off his hand. The penalties for malpractice during King Hammurabi's leadership were very severe, as you can say, or as you can see. But there's one important difference from how this code and the initial views of malpractice began and how things are now. And that is, in the earliest views of medical errors, it was the results, i.e. what happened to the patient, not the conduct that mattered. And I think we can all imagine that today things are very different. It's not only the results, but more importantly, how we got to those results. There were subsequent Egyptian laws that evolved that began to favor conduct slightly more than King Hammurabi. They provided protection to doctors so long as they had followed established methods of treatment. Now that starts to reflect more like modern day However, deviation from those established methods was punishable by beheading, and there were examples of people getting beheaded for not following what we now refer to as standard of care. Again, very serious penalties that we don't have, but it gives you an idea of how this view of medical errors and malpractice evolved to where we are now. Our current societal views focus on the conduct of medical providers, and that is done especially in relation to their peers. And we'll talk about how you evaluate medical conduct in relation to one's peers when we get to the definition of standard of care. Fast forward a little bit, Rankin discovered the X-ray in 1895, and 9 years later, it looks like, of course, we had our first medical malpractice suit involving radiology. This was tried before the Minnesota Supreme Court in 1904, Henslin versus Wheaton. And the story goes something like this. A lot of these are actual quotes from different takes that I could find on this case. They're sometimes humorous in how they phrase different things. All of them start off by defining William George Henslin as a bachelor in his early 30s. I have no idea why. He was having dental work done, though, innocent enough. During the course of treatment, he had a gold crown that came loose and quote unquote disappeared down his throat. He was not able to confirm where it went. The doctors did not know where it went. Subsequently, they wanted to find out where the gold crown went and make sure that it wasn't going to hurt him. The patient had a cousin who was a physician, and his cousin thought that it had gone into a lung. And therefore, he recommended additional consultation, especially consultation using radiologic imaging, which at the time was a brand new, almost magical capability that we had in medicine. Upon initial examination, Dr. Dennis, who was a radiologist with 4.5 years of experience, took Henslin's history. He performed a physical examination, and based on both of those, he could not confirm or rule out the presence of a metallic object in Henslin's lung. And thus, the physician decided that Henslin needed to sit down in front of a Rainey Weineshurst Holtz X-ray machine. I've never heard of this type of X-ray machine. From what I could gather, it was all similar to all the initial versions that were used in medicine. And made patients very happy, as you can see, where the physician actually viewed a live image on a phosphor generated by an X-ray tube over here. You could have the patient turn around and get many different views while they were in the X-ray machine. For 30 to 35 minutes, the physician examined all the planes of the patient's thorax through an eyepiece. After nothing was found, the physician taped a photographic plate to the patient's chest, and he conducted an additional exposure lasting another 30 minutes. So the patient had over an hour of continuous exposure on the first attempt to find this metal object they suspected was in his lung. Neither the live viewing or the development of the film showed the presence of any metallic object. That same afternoon, the patient then returned for another 35-minute session and a second try at exposing the object on another photographic plate. So now he's looking at more than 2 hours of exposure. This was driven by the patient's cousin, again, who was a physician. His name was Aaron Henslin. He came with the physician and worked with Dr. Dennis, on March 4th, 1902, to try and identify whether or not the tooth was in his cousin's lung. Dr. Henslin confirmed that he, too, could see nothing on the two photographic plates that had already been made. With the apparatus activated, both physicians, for a period of 30 to 35 minutes, sought to detect the foreign body, and that effort failed. Then, for another 30 minutes or so, another attempt was made with a third photographic plate to detect the foreign body, but that was unsuccessful. Dr. Dennis then recommended that Mr. Henslin go elsewhere to see if another laboratory could image him any better and identify this foreign body that they seemed to be so convinced was in his lung. He did that. That effort also came up empty. So after all of this exposure to the patient, Dr. Dennis's diagnosis was no more distinct on March 5th than it had been previous to beginning all of the imaging. And as you can imagine, around March 19th, Mr. Henslin's back began to feel painful, and you can see an example of the abscess wound that began to form on his back subsequent to the radiation. In Henslin versus Wheaton, this was the actual Supreme Court case that was taken up. The plaintiff sued the physician for burns to his back sustained as a result of radiography. Judge Brown ruled this is the first case involving alleged negligence in applying recently discovered X-rays. So this was the beginning of evaluating radiography in terms of medical negligence. No rule of care in such cases has been laid down previously. The rule applicable to the care and skill required of physicians toward their patients in other cases applies. This was the beginning of viewing radiologists the same as any other physician with respect to their patients. This is a foundation upon which MR safety has evolved, and in fact, just to this year, to view Mrmds legally as the party responsible for safety in the MR environment. I tried to find out what happened to Mr. Henslin. Those of you might be familiar with radiation burns and subsequent interactions. This abscess went away, and then he later developed a much larger abscess that came on within, I think, 2 months, and that had to be corrected surgically. I couldn't find any evidence of Mr. Henslin passing away due to his injuries, though. Okay, medical malpractice and standard of care. So our modern understandings of malpractice have come to focus on standard of care, and that's defined as the level at which a reasonable, prudent provider in a given community would practice. And that's commonly referred to in law as the reasonable person standard. And I want to emphasize one thing here. In all of the definitions, it is identified as a reasonable, prudent provider, not a radiologist. There are many examples of medical malpractice suits being filed against allied health professionals, such as nurses and technologists, as well as even PIs of large research studies. So in that case, they would be scientists. So medical malpractice is not something that is limited to physicians. They just, in general, have been viewed as the primary targets of malpractice, primarily because they hold medical malpractice insurance. But this does apply to any provider that is practicing. The standard of care is met if the radiologist can demonstrate that he or she acted in a reasonably prudent manner under the circumstances. And the test that's applied in court cases is how would a reasonably competent and skilled healthcare professional with a similar background and in the same medical community provide under the circumstances that led to the alleged malpractice. And so there's this thought experiment that happens in the court where you think about a similar competent and skilled healthcare professional. Again, it's important to recognize with the similar background and in the same medical community, how they should have responded in the situation that's being evaluated. Although the ACR recommendations do not define standards of care, and that has been held up in numerous court cases, the courts have nonetheless given significant weight to standards published by the ACR when they decide how a reasonable person would have acted in the case. The way to interpret this is the ACR is an independent body. They do not just define standard of care. However, the ACR publishes quote unquote standards. They've changed the term to technical standards in the last 10 or so years. But nonetheless, they publish standards that are generally accepted by the community. In court cases, expert witnesses provide testimony as to what they think the standard of care is. And overwhelmingly, those court cases and those medical experts have followed standards published by the ACR. So the ACR is not legally a body that tells us what standard of care is, but it kind of is, at least in terms of practice, when it comes to how the law tries to figure out what standard of care is. What's unique to us and that we need to remember, and this is on the ABMRS test, is what is that the reasonable person in this case is defined by the patient's expectation. It's not defined by our expectations. So although a physicist, a technologist, a nurse, or a physician may have some idea of what a reasonable person would do in a given situation, that idea is actually defined in court by the patient's expectation. As you can imagine, they may have different expectations than we as professionals do. In radiology, the act of interpreting an exam is widely held to establish a physician-patient relationship, and thus is a requirement to meet standard of care. And this is something we talked about a lot in the first presentation I gave, the introduction that got into the new ACR MR safety manual. We've had a number of emails back and forth with many of you talking about whether or not that's fair, and whether or not the radiologist should be held to having entered into a contractual relationship with the patient, even if they haven't seen the patient, or don't know anything about the patient aside from reading their image, and then further extrapolating that to how that impacts how the patient is treated or cared for in the MR setting. Nonetheless, this is a widely held view that the radiologist is in fact involved in a physician-patient relationship by simply reading the image. This brings us to captain of the ship doctrine. The captain of the ship doctrine, again, as I mentioned, is a legal framework that has been set forth. It developed initially out of surgery. As you can imagine, it specified that during an operation in an operating room, the surgeon of record is liable for all actions conducted in the course of the operation. And the reason for that is there were numerous times where a surgeon might tell another health professional to do something or instruct them to do something. And in that case, the professional may not actually report to the surgeon via organizational lines of reporting, because often the allied health professionals, as we all know, are employed by the hospital, and the surgeon or the physician are often independent contractors. And so there didn't exist a direct relationship, a reporting relationship, but nonetheless, the surgeon is viewed as the captain of the ship, and therefore when they instructed or instruct someone in surgery to perform a certain task, the surgeon then becomes liable for all of the actions during the course of the operation. This captain of ship doctrine has been adopted across essentially all areas of medicine. It's a form of the so-called borrowed servant doctrine, in which a party that's usually liable for his, her, its, or their actions is absolved of responsibility. So in this case, we're thinking about the MR technologist, when that borrowed servant is asked to do something that is outside the bounds of policy. The idea, of course, being if the radiologist asks a medical professional, a radiologic technologist or a nurse or someone else, a physicist, to do something that is outside the bounds of policy, they're doing so because that captain of the ship has determined that doing so is necessary. And of course, that person then takes on the risk of, sorry, I'm just making sure the chats are not related to me losing my audio. It sounds like everything's okay though. Okay, sorry about that. Let's see. According to the ABMRS and the ACR, the captain of the ship doctrine is applicable to the Mrmd. Again, I know we've emphasized this previously, but I just want to bring it up again. It is viewed widely by the medical bodies that are often referred to in court, that the captain of the ship doctrine is applicable to the Mrmd. Okay. Moving into malpractice, radiologists currently account for 3.6% of the US physician population, but they rank 6th overall in the number of malpractice suits in which physicians have been named as defendants. So they're abnormally high when it comes to how often radiologists are identified as defendants in medical malpractice suits. Each year, approximately 7% of radiologists face a lawsuit. That surprised me. Over the average course of a radiologist's professional career, 50% of them will experience at least one, will be named at least once as a defendant in a lawsuit, a medical malpractice lawsuit. And 60% of radiology lawsuits result in payment to the plaintiff. Of course, that doesn't mean that the radiologist was found guilty or found to have performed medical malpractice. Often these are settlements that occur. But nonetheless, at least 60% of the time, it does result in payment to the plaintiff. So it is very serious. Radiology and MR is a big area where medical malpractice suits are filed. I could not find good examples of medical malpractice suits as they relate to MR safety. The vast majority of these suits relate to reporting, so actually in the interpretation. And as you can imagine, the vast majority of those are related to missing cancerous lesions, sometimes missing fractures that develop into arthritis and other problems. But there are 4 requirements to establish medical malpractice. The first is duty. A physician-patient relationship must exist, and it has to be defined by a reasonable person. Again, getting back to what we talked about earlier, that reasonable person is defined by the patient, not the medical professional. There has to be a breach of the standard of care. Any breach of a standard of care is considered a negligent act, so that negligent act must be committed. An injury must result directly from the negligence. That's called proximate cause or legal cause. And then 4th, there must be damages. So the injury must be such that the patient is eligible for compensation or damages under the law. These are the 4 requirements to establish medical malpractice. Duty, as we talked about, always exists. At least that is the current interpretation legally between the radiologist who interprets the examination and the patient. The breach of standard of care exists typically when something unsafe happens in MR safety, which would be considered a negligent act if, of course, it is outside what we consider to be standard of care. Vicarious liability, as I mentioned, is almost the same as captain of the ship doctrine, but it's annotated separately in the ABMRS syllabus. So I do have one slide on it. This is taken almost completely from these papers by Dr. Berlin on vicarious liability, as well as another article in Radiology Today he had on supervising technologists, radiologist liability issues. I will send these out to the group or post them to the website with the video. But there are four points that he makes that I think are of importance in understanding vicarious liability. When radiology technologists commit medical malpractice, it is the employer who has been viewed as a legal bearer of responsibility, i.e. the employer is vicariously liable. In this case, when we're talking about the employer, of course, we're talking about the institution that employs the radiology technologist, i.e. the hospital. However, vicarious liability in a broad sense is the legal responsibility of any third party that had the right, ability, or duty to control the activities of a violator. And this is where captain of the ship doctrine comes into play in the medical setting. The rationale for this legal concept is that persons or other entities that order someone else to do something are acting as if they themselves are doing it. And if you might question whether or not captain of the ship doctrine or vicarious liability should apply in MR safety between the radiologists and radiologic technologists, physicists, nurses, or other allied health personnel, ask yourself, can/do radiologists give instructions or orders to technologists, nurses, physicists, etc., to do things? And the answer is, of course they do, and they should. That is their role in the medical environment. We look to our physicians and radiologists to guide us in these areas. And of course, that is an accepted practice and standard in all of our MR settings. By doing so, though, this then creates vicarious liability for the radiologist. In particular, the courts have found that employers who assign specific duties to employees will often obtain financial benefit from these employees, and thus the employer should be responsible for any harm caused as a result of these actions. Again, wearing the hat of vicarious liability, we understand that physicians are often going to become often going to be financially benefited by employees following their instructions or orders, whether or not the employees work directly for them, and thus they are held responsible for any harm caused as a result of these actions. The one example I have, again, it's not an MR safety example because I wasn't able to find good cases that had actually been litigated and decisions had actually been made in MR safety. There is a quote unquote course by Dr. Canal out there that supposedly gives examples of MR safety litigation. You had to pay for it, and then even if I had bought it, I couldn't confirm that I would be able to share it with you all, so I didn't go that route. It sounds like Dr. Canal may have done enough research to find cases in the court records to provide examples. Hopefully in the future we'll be able to do something like that. I wasn't able to do that myself, but I did find a number of good examples as they apply to radiology, and I thought that this was a good one for discussion for us today. There was a 66-year-old male who came in for air contrast lower gastrointestinal examination. After completion, the radiologist instructed the technologist to acquire a bunch of different radiographic views. One that included the anterior posterior view of the abdomen that had the patient upright. The radiologist then left and instructed the tech to perform these acquisitions, thinking that, of course, the tech was fully capable of doing it. The tech asked the patient when they got to the upright scans if the patient felt like they were well enough to stand upright, and the patient confirmed that they did feel they were well enough too. The tech stood them up, positioned them, walked away. While the tech went to turn on the tube, the patient collapsed during the exposure. The patient hit their head and lost consciousness. The patient subsequently developed a hematoma, underwent surgery, was in the hospital for 10 days. 5 months later, the patient came back and filed a malpractice suit against the radiologist, against the technologist, and against the hospital. So this is a real case. During depositions, I actually read the depositions from the radiologic technologist and the radiologist. And the technologist stated that she was simply following the orders of the radiologist. The radiologist told her what he wanted done. She was fully capable of acquiring those views for him, and she did it. She tried to ask the patient if they felt well enough to stand up, and she felt that therefore adopting captain of the ship doctrine, she had done the right thing. She had done what her job, required of her. The radiologist argued in his suit that it wasn't his responsibility to determine if the patient needed assistance. He wasn't even present for it. How could he decide whether or not someone else should be in there helping the patient stand up? Again, understandable. Eventually, the court determined, however, that this patient needed additional assistance to stand up, even though they stated that they didn't, and that this should have been known because of the type of exam that had been given, in particular the use of air contrast, which can lead to fainting, at least the court decided based on the testimony of medical experts. So this is an example of captain of the ship doctrine. At the end of the day, both the radiologist and the hospital were assessed damages. So I think I have that. Yeah, they settled for $300K. So it wasn't fully litigated. They settled for $300K. That was apportioned equally on behalf of the radiologist and the hospital. So we don't have, again, a lot of good case studies to go on, but at least in this case study, something that I think jumps out to me as having a lot of uncertainty in it. The radiologist was viewed as the captain of the ship. That doctrine did apply. The radiologist was found to be at least 50% responsible for the settlement. The technologist was also found, or at least in the settlement, thought to have been negligent, and therefore the hospital which employed the technologist was found liable for the other half of the settlement. Again, just like in the first discussion where we talked about trying to identify cases where technologists have been found personally liable, I could not find any examples of that happening. And all the examples that I could find in radiology, again, I couldn't find any in MR safety, but all the examples I could find in radiology, MR technologist liability was all absorbed by their employment organization, i.e. the hospital. Okay, that is it for the presentation. As I mentioned, though, I wanted to revisit the ABMRS syllabus so everyone had an idea of what the ABMRS believes are important medical legal implications of MR safety. And hopefully the presentation has covered these for you. They specifically only give one kind of overall topic, and that is the legal foundations and building blocks of MR safety. They do go into standard of care and state that standard of care is the basis of it all. And this brings us back to the idea of how would a competent and prudent medical professional behave in a situation that's being examined by the courts. Again, the expectation of how another similarly trained individual would have behaved. However, it's defined by the patient's expectation as we discuss. It's not defined by our expectations as medical providers. They ask that you understand medical malpractice, know that a breach of standard of care is viewed as negligence, and the breach of standard of care if the breach of standard of care was a proximate cause of an injury, then the radiologist can be held liable. Captain of the ship doctrine for medical malpractice in the US, as we discussed. There can be multiple parties responsible, liable for an injury. This gets into primarily the division between the radiologist and Mrmd, who are normally independent contractors, and the hospital or imaging center, which is its own legal entity. Again, as I mentioned, I couldn't find examples of allied health professionals being personally responsible. They were always held liable under the umbrella of the organization that employed them. And then they want you to be familiar with vicarious liability. Again, very similar, if not equal to captain of the ship doctrine. It's not determined by who hires or fires the employee, though. Again, think of the captain of the ship doctrine where the surgeon is in the surgery suite directing folks in lieu of their actions, even though those folks may not report directly to them. If they respond to your guidance, you can be held vicariously liable for their actions and inactions. That's it for the ABMRS syllabus and what they recommend we know about medical legal implications. Again, as I mentioned, I've reviewed a number of example tests that you can purchase from different organizations out there that prepare folks for Mrso and Mrmd safety training. I couldn't find any questions related to medical legal implications. So I think this is something the ABMRS feels we all need to be familiar with, but maybe is not putting a big emphasis on in testing. That wraps it up for our entire course. The course is over. We've covered 8 different topics now. As soon as this video has been edited and uploaded to the website, I'll send out an email to everyone letting you know that it is ready to be viewed on the website. We're getting somewhere around 20 to 25 people who view the modules live in person, and then another 30, sometimes up to 40 people who seem to be viewing them on the website and then taking the test. So we're getting great participation. Thank everyone for your participation. Next steps for us, now that this course is wrapped up, I'm going to send out a survey on Thursday, and I would ask that you please do take time to fill it out and help us make this better in the future. This was our first attempt at making this course. As you all know, it was motivated by requirements from the ACR to appoint appropriately trained MRSOs, MRMDs, and MRSEs at each site that has MR services. I'm sure there are a lot of things we could have done better. So hopefully you'll be able to fill out the survey and give us feedback to make it better next time. We are planning to have certificates available for you to save and print on the 21st. That'll be on our website, mrse.sitehost.iu.edu. You'll be able to go there, search for your email address, and then print a PDF of your certificate showing that you successfully completed all modules and have been labeled now an MRSO, MRMD, or MRSE by IU Health. Finally, we're going to have our first MRSC 2021 meeting on January 6th. It's actually been quite a while since we had an MR Safety Committee meeting because of this course. We had delayed one of our MRSC meetings, which puts us at about a 4-month span between meetings, much longer than we'd like to go. I believe actually Julia Payton, who schedules these, got back to me yesterday and told me she's looking now at January 20th because of a conflict. So I apologize for that. I should have updated that. But my understanding is we're going to be meeting on January 20th now due to a conflict. All of you should be on the invite for it. You have not received the invite. I don't have the invite for it. Julia should be sending that out. in the next few days. If you do not get the invite in the next few days, by the end of the week, I would say email me and Julia and let us know you're concerned that maybe you're not on the list. At this point, though, I do think everyone should be added to the list. The list seems to have become quite robust, but do let us know if you're not included. That is it. That will give us a little time for questions. If anyone has questions or would like to have a discussion, I'll open the chat box and see if there's anything in here. In the meantime, if anyone would like to ask a question, please feel free to go ahead.
Jason, this is Kathy Moran. I wanted to thank you. I thought this was excellent.
Here. Does this qualify us to use Mrso in our title? That's a great question, Larry, and the answer is yes, it does. It doesn't entitle you to represent yourself as an Mrso certified by the ABMRS, but you will be an Mrso certified by IUH, and you will be the Mrso for your site. I do need to do a little research to see if the ABMRS has somehow copyrighted the use of Mrso itself. I don't see how they could have, though, because the ACR requires Mrsos be identified, and their requirement is not based on accreditation or certification by the ABMRS. So, Larry, I'm 95% sure the answer is yes. You certainly will be the named Mrso for your site. The question is whether there's any copyright out there for the actual 4 letters Mrso. I will look into that and get back to you, and I will make sure that I have an answer for you all prior to you printing up your certificates on the website. Let's see, any info available for what was discussed last meeting about cleaning products, magnifying glass, blacklight, etc. I do have recommended vendors for magnifying glasses and blacklights. I'm not sure about cleaning products. I will look at that, and I will send that out after our meeting today. I apologize. I should have done that last week, but I have recommended vendors for those items, and I will send them out after this. Thanks for the reminder. Any questions or topics anyone would like to bring up? You're welcome. I'm glad you enjoyed the course, Dr. Moran. Okay, well, thank you all for your time. I know everyone is extremely busy and devoting an hour or more at times to this course, and then taking the tests, and sometimes retaking it was not easy. I thank you all so much for your feedback that you have given, and that I hope we'll get for you in on the survey. And look forward to having your certificates able to be printed up soon. I have also, Dr. Moran has mentioned to me previously in an email, I'm sorry I did not get back to you on this, that this should be worth CME, and I totally agree, and I just haven't gotten around to it. But given that we have a test for everyone, I would think that we can get CMEs for this. I will email the folks in that office about that here today and try to get information for us. I think that this definitely should be worth CMEs for all of us. So I will take some action to try to find out if we can get that. If we can, Dr. Moran, I'll send that information out to everyone. All right. Well, that's it for us. I hope to see you all at our next MR Safety Committee meeting. Again, it was scheduled for January 6th. Now we're looking at January 20th. We'll be talking about policy changes at that meeting that need to be implemented very soon. One in particular as it relates to Harrington rods and how we'd like to streamline the scanning of Harrington rod patients across the organization. You'll also be able to bring up lots of concerns that you might have about homogeneity across our IUH system and policies up at that meeting, and hopefully be able to get traction and get changes implemented that make your work easier and more homogeneous across the environment, and hopefully make our patients view us more as a single entity that is always on the same page. With that, I thank everyone again for your participation, and I look forward to seeing you at future MRSC meetings. Goodbye.